So I'll introduce our panel starting over here. It's not necessarily in this order, so give me a second while I get it together. But John Edwards is on your immediate left, the New Zealand Privacy Commissioner. And we have Angelene Falk, who's the Deputy Commissioner from the Office of the Australian Information Commissioner. Then Brent Homan is with us, Director General for PIPEDA Investigations, the Office of the Privacy Commissioner of Canada. And then here on my left, Melinda Claybaugh, Counsel for International Consumer Protection with the Federal Trade Commission in the United States. And we have Leong Keng, Executive Chairman, Personal Data Protection in Singapore, and Stephen Kai Wong, Privacy Commissioner for Personal Data, Hong Kong. And I've got you wrong. No, that's it. Yes. Okay, sorry. I thought I had one more person on the end, but I don't. In my mind, I had 10 people, but this is pretty much enough. Please welcome our panel. So I thought, rather than sort of having a number of people sort of speak to you for 5 minutes each and put everyone to sleep in the room, let's try and get down to it if we can immediately. And John, I might start with you. Are there, to mind immediately, those connections, those synergies between the jurisdictions that we have up here on stage, including Australia, that are the positives that we can focus on when it comes to privacy regulations and requirements?
Yeah, very much so. I mean, we spend a lot of time when we come together internationally talking about international cooperation, and we've seen from the GDPR the need for lead agencies and a more formalised cooperation framework. It's actually a bit fraught trying to prescribe these things in international instruments, and our efforts have not been entirely successful. But what we find is that when we need to cooperate, we find a way. So I can get on the phone and call Brent or Keng or Stephen, and we collaborate for the best outcome for our populations. And that works really well in that pragmatic sense, even though, to paraphrase a Treasury epithet from New Zealand, it works really well in practice. We just can't make it work in theory.
That's a very funny line. Does it matter that it doesn't work in theory? I mean, that's really only something that would concern the Mandarins, I imagine.
Yeah, I don't think it does matter. I mean, I think all the jurisdictions that are represented in this room have a commitment to respect individual privacy. That takes different forms, and the regulatory models are slightly different everywhere. But we make it work. Now, there are some countries where there is no such effort, and that is more of a challenge. So. Yes. But, it doesn't really make a heck of a lot of difference to us, I think, whether we are having to try and work with the FTC or the California Attorney General's office to kind of frame something in a way that they can understand, or whether we, ask a colleague to exercise their powers in their own jurisdiction.
Brent, you were nodding along to something of what John was saying there, particularly about getting on the phone and having a chat. So,
well, absolutely. Where there's a will, there's a way, and we've had the privilege of cooperating with virtually every member of this panel. I'm looking over at Commissioner Wong and thinking about an instance where we had an issue with a Hong Kong tailor that was spamming Canadians. We got on the phone with the Commissioner's office, and it was resolved in a very expedient manner. And I think that's where you look at some more informal and expedient resolutions, but on the other end of the continuum, and that's really what it is, enforcement collaboration is a continuum. From low level and very less complex issues to highly complex issues. And I think the best example of a highly complex issue, it was referred earlier, I think everyone's heard about a company called Ashley Madison. Well, that was a Canadian company.
A proudly Canadian.
Proudly Canadian company, and engaged in extreme dating, or I'm not sure how you describe it. However,
extreme dating is an excellent way to describe it.
So in that situation, it engaged people on a global basis. I think there was 30 million affected individuals around the globe. And so the response to that was a joint investigation and collaboration between our office and the Australian office, and as well with the US Federal Trade Commission. And the magic of that is that it really is the sum is, the total impact is greater than the sum of its parts.
Yeah.
We're able to take a holistic approach, address the issues with respect to the security safeguards, but as well there was issues relating to more consumer protection issues. One thing that they had was a security trust mark that was on their website, talking about basically conveying how secure their website is. The problem with that award is that they gave it to themselves. And so that was an issue of misleading, of deception leading to consent. So the fact that we could address these issues from our various jurisdictions really went to a holistic approach at the end.
Melinda, can I get you to reflect on that as well? I mean, because we've had the US mentioned before, and in particular the freedom of speech as an issue kind of, rubbing up against some of the issues we've been talking about today. Is there ever a cultural roadblock or impediment to this, very sunny Pollyanna view of everyone sharing and caring so nicely? There's got to be a catch here somewhere.
No, I think that in my experience in practice is very similar to Brent's. Sorry to be too Pollyannish about it.
It's all right, I'll get to the truth eventually.
Yeah. But I think that the practical on the ground enforcement level contacts are important for the day-to-day connections. Brent was talking about calling up Stephen's office. But I think also very important is having the frameworks in place to be able to share the information in a way that often you're sharing very sensitive information in order to further your law enforcement investigation. So not just having on a practical level the contacts, but also having the framework for being able to share sensitive information across borders with our counterparts.
And what do you mean by framework?
So, for example, we've got several examples. I mean, one, the FTC has memoranda of understanding with various agencies around the world that basically govern the terms of our enforcement relationship. Yeah. So we'll keep certain information confidential, et cetera. We'll let you know if we use it in court, that kind of thing. But a key one, particularly in this part of the world, is the cross-border privacy enforcement arrangement promulgated through APEC. And that has really been the tool that's allowed a lot of cooperation. For example, in the Ashley Madison matter, that has really kind of allowed agencies to share information you need to share when you're working on a confidential investigation.
So just to drill, if we can, a little bit into that issue of where data collection, data use, and data privacy might rub up against freedom of speech and those provisions in the Bill of Rights in the United States. How do you see that playing out? I mean, is there a contradiction there? And has that caused any conflict?
I don't think so. I mean, I think that issue was brought up with respect to data portability, and I think Michael from British Columbia mentioned that, and I think that is potentially an issue when you talk about data portability, but I think largely there's a lot of overlap in all of our privacy regimes and the way we view the world. Now, I think that the US may, on paper, have a different kind of legal approach in terms of having a sectoral regulatory approach. We don't have a standalone federal privacy law, but I think all of the concepts that we're all dealing with in terms of security safeguards, privacy by design, transparency of notice and consent and all of that, we're all working with those principles and implementing them. Stephen,
the example that's been brought to bear or being discussed here about any sort of cultural differences, even with your great ability to communicate and connect with each other, are there impediments there? When it comes to your jurisdiction?
To a certain extent, yes, because these local cultural differences may be reflected in the laws of the location or the territory, and perhaps the mindsets might be different, and as a result of which the operation or the enforcement of privacy rules might have different considerations. So we try to share these cultural differences included, at our next conference in September in Hong Kong, where we will ask a number of jurisdictions from the neighboring countries or regions in Asia to share their national legislation and framework, and also the practice of enforcement.
Keng, can I get you to reflect on the opening question of the synergies and the the connections that exist between these countries and jurisdictions?
Well, Singapore is actually very new in the game. I think we only put our act in place in 2012 and started operationalizing it 18 months from there. So we're relatively new. And I think the ability to share at such a forum, we found it to be extremely useful on two fronts. One is that we have the benefit of sort of finding out lessons learned from people who have walked the path much longer than us. The other advantage, I guess, or the other opportunity is that being relatively new, well, we're actually in the process now to review the Act, even though it was put in place in 2012. Right. And that's largely driven by our concern of basically the digital economy, all the technology that brings the disruption that comes about. And I think that has a tremendous impact on perhaps how we view data protection, how we view things like anonymization, data sharing, etc. So we're in that process, but we felt that such a review is necessary to take into consideration some of the disruptive forces.
Yes, I wanted to ask that whether, I mean, I think we've had a fair ventilation of the Australian and the Canadian and the UK situation in our earlier discussions today, but do you feel that your Act is being reviewed, you say, is that as a consequence of it not keeping or not reflecting the times when it comes to the digital economy?
Yes, largely driven by the pace of change, because even though we put our Act in 2012, the usual concepts like, consent, etc., while we think that those principles are valid, obviously, and I think there's always need to take individual rights into consideration, but many of the technology disruption perhaps make some of these concepts, we need to find another way, or other ways of dealing with, for example, how can we take consumers' interests into mind, where specific consent is maybe not practical. So I think these are things that we are exploring to allow for some of these new technologies and disruptions to take place.
Stephen, is your Act reflective of the times, do you believe?
Yes, I entirely agree with Mr. Leong. Perhaps further opportunities could be explored, especially when we focus more. We should be more focused on, for example, the consumer protection agencies, the cybersecurity protection agencies, and so on, so that we could get ourselves updated with the new technology. And there is no way that each DPA should keep its own IT team or security team. So the sharing information as suggested by Melinda should be very helpful.
Yeah. Angelene, can I turn to you, as Australia was sort of the host of this most recent APPA forum. What would have been the key privacy themes for businesses in the Asia-Pacific region that have emerged over the last couple of days?
The last 2 days has been spent by the regulators that are on the stage today, but also others who are in the room, other countries like Korea and Macau and Philippines and Japan have joined us as well. And the kinds of things that we've been talking about have all been borne out, I think, today in the conference. So in terms of new technologies, issues of data breach notifications and law reform, but also the issue of the GDPR and how it might impact on economies in the Asia-Pacific region. And despite the kind of Pollyanna picture that we might be painting, those 2 days of meetings are a very robust discussion where we are very much wanting to both learn from one another but also to critique one another's approaches. But at the end of the day, despite the cultural and legal differences, our similarities are really much more strong than our differences. So in terms of the issues, I think, that were borne out for business really to be thinking talking about, which were borne out today, but also over the last couple of days with the APA Forum, it is about how do you comply as a business in a global economy with various laws that might apply.
Yep.
And the kinds of things that we heard this morning around ethical data stewardship and trust were really strong themes in terms of the work that all of the data protection authorities are doing, not only to ensure compliance but also better practice. And that kind of compliance and better practice can take a number of forms, but there's key similarities between all of our regimes. So issues like having accountability programs in place, privacy management programs, sometimes are referred to in that way, having roles designated to deal with privacy issues, taking a privacy by design approach,
yep.
Using privacy impact assessments. So they're all key tenements of the GDPR. From Australia's perspective, many of those are already implied in Australian law. So we can see real opportunities to embed that within the Australian business practice. But also we did see amongst our Asia-Pacific counterparts various mechanisms that are being explored by other jurisdictions. For instance, the idea of trust marks, whether or not there can be some kind of certification.
You mean like the tick or something, yeah? That's
right. Yeah. So I think that idea of having accountability, which is both internal in terms of having internal processes, yep. and mechanisms, but also an external face to that.
Some sort of consumer mark. Can I get the panel to reflect on that? Just on that point, because that's actually a new idea that's now, or at least has come into the room today in our discussions. Any reflections on that?
Yeah, actually, I think that's one area that we are pursuing. Well, you may have read that we announced Singapore's intention to participate in the CBPR in May of this year. So we are in that process of doing those preparations. But in conjunction with just cross-border data transfer, we thought that it might be also useful to incorporate it in some of this domestic kind of certification. So we are in the process of thinking whether we would want to introduce a trust mark idea. So along the lines of maybe ISO certification, that sort of concept. Yeah. Basically to give companies who have done well in protecting personal data to signal to their customers, to their stakeholders that I've done this, So we're in the process of thinking, and certainly trust mark is something very interesting to us.
Brent?
And I think the concept of a trust mark is coming organically at the right time. Consumers care more about privacy than ever, and they're looking for indications of how they can feel comfortable with transacting with a specific website or an organization. And that said, I think it'll be important to do work on trust marks because as well, as mentioned with Ashley Madison, there is the ability sometimes for people to abuse or create other trust marks. Sure. We've seen 15 years ago when it came to environmental advertising and greenwashing, all these different types of trust marks, real or non-real, right. that popped up, and it just serves to confuse consumers. So to the extent that there can be established some type of trust mark in privacy that people recognize and can have confidence in, that's a good thing.
So maybe to throw a little cold water here, stir up a little controversy. No, I think.
Oh, thank goodness.
I think that trust marks and seals and certifications can have a very important role. I would say at the same time, as the Federal Consumer Protection Agency in the U.S. They can sow confusion, and there are some pitfalls that go along with it. So one, you want to make sure that the standards that the company is either self-certifying to or a third-party agent is certifying are available and clear and publicized. But you also need the relevant enforcement authority to be able to monitor the use of the seal or certification so that it's not being abused because just based on past experience, that is a possibility. So I think it can be a good option. I think there's a lot of infrastructure and thinking you need to have in place in order to make it effective and useful for consumers.
We'll hear from John, but also please get your hands up if you've got a question or a comment you want to join our conversation. Time is on the wing, so don't waste too much time doing that, and I will come to you, John.
Thanks. Yeah, I'll just make a contribution about the trust mark because we're looking at something like that as well. And we've, the discussion normally goes around, is there a conflict of interest? Do you restrict your ability to enforce? Who's your accountability agency? And it quite quickly builds into this really quite engineered process, which requires a whole lot of different moving parts. We've found in our surveys that there's quite a lot of support for the concept from consumers. But from a regulator point of view, I'm actually quite interested in some mechanism for giving out rewards for good practice. So not necessarily having this, I am 100% compliant, but just a note to say, the Privacy Commissioner thinks this is a good product, or this is a good app, or nice process that you followed here, and maybe a gallery or something like that. So we're in the process of looking through those options.
Before we get to some questions in the room, which I hope are coming soon, Brent, you said something, and I've been reflecting on this all day, and I think our series of conversations has sort of been leading us here, where you said that consumers care more about privacy now than ever before. And I don't know if that's true. And I think there's a real challenge here for the privacy commissioners, for all of you, and a real opportunity here for businesses, and to push back against the privacy regulations you might want to put in place. And I don't know if we can sort of reflect this accurately in the room we've got here today. Anyone in this room who's under 25? Not a one. Not a one? Okay. I think I can safely say that for that generation and below, they don't care as much about their privacy. Of course, you'll all disagree with me, but I'm going to make the argument nonetheless. Okay. And even if they do care,
have your children blocked you from Facebook?
Well, wouldn't you? And even if they say that they do care, and let's say they mean it, we're more willing than ever, and we have spoken about this, to check that box, to tick that, to click to say, yeah, you can, yes, I give you my location, yes, I give you that, yes, you can push notifications to me, and so it goes on. The willingness now, that has just become part of what you do when you operate in the online world. So as regulators, how are you going to deal with that? And Stephen is the one who most wants to strangle me right now, so we'll start with you.
This is the same finding that we had after a survey, or in fact, there are so many surveys conducted over the last few months in Hong Kong, indicating that the younger generation simply does not care about their privacy right, because most of them will say it's too late now. And so this is one of the reasons why we put on hold the privacy mark scheme, because we mentioned it 2 years ago, and then we assessed the cost effectiveness of the scheme. We found that the cost is too high, certification, and the effectiveness, for example, the majority of the younger generation does not appear to appreciate, the work that you try to protect their privacy rights. So this is one of the concerns that we have in mind. We'll keep reviewing it.
Yeah. Who else wanted to strangle me? John and then Brent, yes?
No, look, I do push back on that. I think that the concept of privacy is changing and people are asserting their autonomy in different ways. But I think it's a real stretch to say because we are sharing a lot or not being, not reading every last word of a privacy statement, that those people don't care about privacy. They do it instinctively. I've seen 9-year-old kids signing up on websites with fake email addresses just to access the services without the spam or whatever. So I think that there's a lot more nuance that we need to introduce into that conversation rather than just it's on Facebook, therefore that nobody cares.
No, I think there are degrees, but I think a younger generation actually divides the idea of privacy up into different subsets and sets. We now have some questions. We have one over there. I'm going to take the microphone. We'll hear from Brent, and then we'll come to you, and then I'm coming to one up the back here.
Yeah, just as the willingness to click a box should not be taken as a proxy for not caring about privacy.
Absolutely, and that's your job to actually take that greater care. I get that.
And in fact, privacy isn't secrecy. It isn't being locked in a box. Privacy is having control, having control over what happens with your information. So I can choose. I don't have to be a privacy zealot. I can choose what to do and what to share with my information, but as long as I have that choice and I have control, I'm in control of my privacy.
Go right ahead.
I'm probably another person who wants to strangle you for saying young people don't care about privacy. My name's Mia, I work at Facebook, and I would just like to echo Commissioner Edwards' comments. We held some workshops with young people and the Australian Privacy Commissioner last year, and actually when you sit down and talk to young people about how they use technology, they're incredibly sophisticated and could probably teach us a thing or two. One example was they would all go out to parties and then they would create a secret group and they'd all share the photos and then they'd all agree which photos to post so everyone looked awesome. And then they would all have these conversations and agreements with each other about when and how to tag people in photos. And all of those, and I think it sort of echoes our Canadian friends' comments as well, I think all of those things, they might not be using the word privacy, they might not be like reading the whole privacy policy, but they're instinctively making privacy and informed privacy choices and creating those conversations routinely throughout their day.
Okay, good. I still think that's just hiding stuff from your parents, which you've always done. But anyway. Over here, if we can get the microphone over there. It might take a little while to go. Whack your hand up again so we can see you. We'll get the microphone there. Did you want to reflect on this issue at the moment, Melinda, before we get to our question here?
It sounds...
Yes, and Keng, we'll get to you too.
No, it sounds instinctivally wrong to me, but I think that, and I think I would agree with some of the other comments on the panel, but I don't have the data to back me up.
Well, if you don't have the data, then that's it.
I don't necessarily think it's an age issue, but I think it's IT savviness, and obviously I think the younger generation, they are much more savvy with use of technology. I think they are all making choices of benefit versus risk. So a classic example, maybe this is a very Singaporean thing. We asked one of our questions, and this is wide range of age group, not just the young, whether they're prepared to give up their personal data in order to get a lucky draw, and they all said yes. So I think, I think it's just that at the moment they are just balancing the risk versus the benefit. So it's not necessarily that it's because they're young, but because I think the technology provides these kinds of opportunities, and I think that's what's driving them.
Yes, you have a question here. Right up high. It's okay, don't touch it, they'll fix it. Yep.
It's actually more of a, I think we're touching on a theme here because I've actually had an experience where I've actually built tools for schools to introduce and talk about privacy to kids. But the interesting thing was when I got my son to actually read it, the answer was, yes, Mom, I've read it. But when I said, no, do you really understand it? Basically, if someone gets this information or your PS4 information, they can steal, if they steal it, they can get all your credits, they can steal all your friends' credits, and they can say that you did it. And similarly, how you consider your profiling on Facebook. That's when I had that look in his eye. And he then went, oh, and I knew it was effective because we share a similar, when he was younger, we shared emails, basically, as a form of monitoring. And I saw a whole stream in excess of 10 applications change passwords straight away, which got me thinking, it's potentially how we are actually communicating with them.
Yes.
About how this actually brings meaning to them and how the literature is actually targeting to it. So I think there's a little bit of truth in everything everyone said about, benefit versus cost, how they're actually relating to it, and that they do actually care about it, but it's understanding it in a language that
and understanding what privacy actually is. Because I still believe with young people in my life that generationally there's a slightly different understanding of that general concept. You old people, you. Did anyone want to respond to the observation that we just heard in the audience there? No? Okay. It sort of stands alone. So why don't we go through and get a sense from all the countries that are represented here, the jurisdictions, about just how strong or how significant the tension is at the moment between you as regulators of this issue versus private enterprise and what they're wanting to do, the data collection and use and ongoing use that's going on, and over what particular issues and where those tensions come in. We've noted you as a question, so we'll get the microphone to you. John, can we start with you?
Yeah, I think that increasingly we're seeing private enterprise seeing the value in promoting privacy values as a part of the brand. Not necessarily because of any inherent virtue, but because they see the counterfactual. They see the flight of value from their brand when they get something wrong.
Okay. Well, that's interesting. Is that your experience as well, Brent?
Yeah, and actually this still counters the fact that, or the assertion that people don't care about privacy.
Yes,
I'm still on that.
Of course.
But if you look more and more, and what we've seen is a growing intersection between privacy issues and traditional consumer protection issues. And look at the free market. Look at how businesses operate. To the extent that they feel that it's profitable to market privacy to individuals, which they're doing more and more, then that's an indication that individuals do care. So what does that mean? That means that we're all of a sudden looking at different types of issues when we're considering traditional principles such as consent. We're looking at the use of privacy as a marketing feature, and how does that interplay with traditional thoughts about privacy.
Melinda?
Yeah, I mean, I was just struck by your comment about the intersection of consumer protection and privacy, because that's exactly at the heart of, well, we're a consumer protection agency that focuses on privacy. And I do think you're seeing more and more the overlap of those issues, in particular around notice and consent and choice and all of those traditional issues. So yeah, I think we're going to continue to see that more and more. But
is there significant pushback in the United States, against that? I'll use the word encroachment, but only from the mindset of of business and private enterprise from them against these sorts of principles and demands on them.
Well, I think there's always a tension. I think that there's always a request among industry for more clarity, more understanding about what exactly is going to be required of them. So I think what we've tried to do is really give very thorough business guidance and try to get ahead of particular issues, particularly around particularly around emerging technologies. One thing we've been looking at recently is connected cars and a lot of the issues that come up with that. So we want to encourage the development of new technologies, and we don't want concern about privacy requirements, privacy laws to hinder the new development, but we also want to make sure that privacy considerations are thought about in the development of new technologies.
Keng Tai, what's the Singapore experience been like?
I think there are probably two levels of reactions from the big MNCs, big global operators, especially those in the IT areas, new technology areas. Actually, our interaction with them is pretty high, and I think the engagement level is also very high, and we tend to sort of try to understand where each other is coming from. So I think that relationship is very healthy. The pushback largely comes from SMEs, small firms, which I think instinctively they think that, such a piece of legislation or such regulations will add additional costs to their operations.
And does it? Do those regulations add more layers of cost?
Well, it wouldn't be zero for sure. I mean, there will be things that they need to do, but a lot of times we tell them that actually the cost is just rethinking about practices as opposed to putting in huge IT systems and stuff like that. Yeah. So it's just being aware and look at it with a consumer in mind. So with that education and awareness creation effort is a lot that we have to do. But I would say that generally there are two levels of reactions.
Is anyone arguing in Singapore that the cost of compliance is too high?
Well, the SMEs.
I mean, and do they? But try to look at it as independently as you can, given your position. Do you believe they have a point, or at least half a point?
I don't think so, because, like I said, many of them, firstly, there will be situations that they actually do not need to collect and hold personal data. It's just legacy. It's a habit that they want to collect everything. So if they think about it, they don't need it, they shouldn't collect it. So things like that actually cost nothing. It's just about thinking through. Yep. But of course, if they really deal with a lot of personal data, even at the SME level, then I think rightfully so they should spend some effort to ensure to protect that kind of information.
No, it's only data collection required here in Australia, isn't it, really? Haven't got to the metadata discussion today, have we? Stephen?
Yeah. I do believe that education is as effective as enforcement. So we do engage the private enterprises with a view to giving them the guidelines, guidance and advice on privacy protection, and to the extent that we also ask them to respect personal data. Interesting enough is the public organizations, including the government, who fail to comply with our principles from time to time. So what we're trying to do is to embark on a campaign or in some sort of a publicity program for the government departments. So
that would be a very funny publicity.
Indeed, yeah, indeed. And especially on the recent cases involving elections, for example.
Yes.
And the data, the personal data of the
right.
electors. So, and given the fact that in Hong Kong, the violation of a principle or data protection principle is not of itself a criminal offense. So 99% of those who receive enforcement notices from me comply with the requirements immediately.
Right.
So they are very cooperative in that sense. And the remaining 1%, they are very persistent. In one case, they were convicted in court and fined, about 30,000 Hong Kong dollars, which is 3,000 US. 3,000 US.
Roughly, I think.
Yeah, 3,000 US, yeah. And they spent a lot of money,
fighting
it all the way to court. Reason, trust, reputation, damaged.
No. We have a question over here, I think. Hi, go ahead.
Hi, my name is Matthew Quick from KPMG, but before this I've worked in corporate. Thinking through the synergistic sort of aspect of it, my experience certainly in corporates in Australia, and I don't know if it reflects everyone's, has been that I've never worked at a business that has actively gone out of its way to not comply with the obligations it's got. But the difficulties that they've had is understanding the breadth of them around the world in all the markets they operate in, linking it through some of the concepts today around trust and these sorts of aspects. Sitting here listening to the collective wisdom of all the commissioners that are up on the stage and here today, I mean, this is probably shooting myself in the foot coming from a consulting firm. The lawyers in the room probably kill me as well. But I've made good money going out to clients and basically saying, oh, here's what the laws are in this country, here's what the laws are in this country, here's what the laws are in this country, and this is how they align.
Yes.
And on the other side of the fence, I've spent good money doing the same thing. Has there ever been any thought or discussion amongst yourselves in a perfect world saying, well, if we were to just publish or have ready to go a database, for want of a better term, of what our various laws are and where they align, and you can go in and get it, from an employee's point of view, that would be fantastic to be able to just take that and implement it.
Okay, well, let me put the question and see if there was, but I still think that you'd probably earn good money doing what you do, even if there was that database in place. I suspect. Melinda?
I was going to say, you sound like you've got a great business idea. You should do this. I don't think we should do it.
These people don't want to do you out of a business.
And then I can come work for you. I'm just kidding. Joke. So no, I don't know of that database. It would be great if there was such a database. I mean, I think there are various efforts that various law firms and others do periodically, put together the compendia, and I mean, that's what I look at when I need to answer a question like that. But I think you're right that that only gets you so far. All of us have many laws in our jurisdictions that might apply in a particular instance. So I'm not sure it goes the distance. Although I do think that there is a convergence globally of a lot of the key concepts in privacy. So I think despite the kind of maybe the laundry list on paper of all the things you need to comply with, at core, if you're doing the key things we've been talking about all day today, you've gone a long way towards compliance.
Angelene?
A little bit in answer to that question, but also the previous issue around the tensions in the Australian environment. And one of the things that you're raising there is, well, can we have a kind of Brightline test that applies globally around data protection? I think we've heard today around the complexity of technology and so on, and some of the challenges with that. But despite that, I mean, one of the benefits that APA brings is that we do collaborate on guidance. We do seek to find commonalities in terms of frameworks and so on. And perhaps an example of that is issues, for instance, of what is the meaning of personal information globally and some of the differences there. In Australian law, there's an element of judgment that's required in relation to that test. Businesses often want to have a bright line answer to that. I think for us, one of the things that is a benefit of our law and is present in many of the regimes globally is the fact that they're principles-based. They do require an evaluative understanding of notions of reasonableness. They can be applied in different contexts, so that's their strength. The downside to that is you don't necessarily get black and white answers. So one of the big discussions that we had in APRA over the last couple of days was about when is something no longer personal information, when is it de-identified, for instance. And many of us are working on guidance and frameworks for a risk-based approach to de-identification. And I think there's still an ongoing discussion around the extent to which de-identification is a privacy-enhancing tool in this era of very much open data and connectivity. But notwithstanding, we look to have common frameworks, and I think that's one of the contributions that we try to make as Asia-Pacific authorities.
Did you want to jump in there as well, Brent? You seem to be...
Yeah, and I was just thinking that, just in response to the question, and very, very much in line with what Angelene said, I don't think the objective is to have an encyclopedic understanding of every jurisdiction's laws, because by the time you get it, everything's going to have changed again. So, but rather kind of focus on those guiding principles that are very common across jurisdictions. Now, I was thinking about this morning and listening to the good work that's being done on issues of de-identification, trying to kind of think about the intersection of concepts such as trust and ethics and algorithms. And the one thing that occurred to me is that of all that, perhaps one of the most important ideas would just to be take a step back and think generally, what are you using the information for? Put yourself in the shoes of the consumer and ask, would that creep me out? Would that bother me how it's being used? That's, and if so, that's probably a good idea that you're contravening some kind of privacy law.
I actually think it's sort of a perfect summation of where this whole day has come to, Brent, and I know that we are keen to get out there and have our evening drink and also to hear from the Commission before we wrap for the day. So I'm going to call that a wrap for our conversation here on the stage. Would you please thank all of our international commissioners for this afternoon? Thank you, guys. That was fantastic.